Well, thank you for joining us. This is a panel for Patent Quality Week, which is kicked off on Monday, and we're going to be discussing the importance of patent quality both in the system and how to avoid bad patents getting in the system in the first place. So with me today, I have a great panel pulled together that represents, I think, some of the most important aspects of the discussion of patent, and that is some of the tech side of the debate as well as the debate on the pharmaceutical side, because these are two sectors of the economy where patents weigh in fairly heavily, and they can actually have a good role or a bad role depending on how the patent system is enforced and played out. So today I have some guests here. I have David Jones from the Tech Inventors Alliance, who has been in the patent world for quite some time. Daniel Takash from the Niskanen Center, who has also been working on patents and their role in how to make efficient allocations of resources within the patent system. Preeti Kristel from IMAC, who does a great deal of work and important work on the pharmaceutical side of patents and how that impacts patients and consumers. And Matthew Lane, who is the head of the Coalition Against Patent Abuse. So what I want to do just to kick things off, and I just go around the horn and talk about patent quality from your perspective and why it's an important issue. And Dave, I guess we'll start with you.
That sounds great. So, I get frustrated sometimes with DC conversations where people seem to say, oh, patent quality doesn't matter, and the only thing that matters is getting a patent in the hands of an inventor because that's going to drive innovation. The goal for these people, I think, is to make patents cheap and easy to get for inventors, which I think is half the system, but not the goal of the system, right? And has some real costs and real problems associated with it, right? And then a lot of times the assumption is, oh, well, if we grant a few too many patents or grant patents of not ideal quality, it's just going to cost a few big corporate defendants a little bit of extra money to defend the lawsuits, and that's not a big deal. I have a very different view on patent quality. When an invalid patent is issued by the patent office, that usually means that the patent is issued for something that doesn't qualify as an invention because it's not new, right? And in turn, that means that someone other than the original inventor is getting a patent. That's a fundamental problem. If a patent is granted to the wrong person, it can't create an incentive for the actual inventor, for the right person, to engage in innovation. So it's just fundamental to the patent system to be able to distinguish between new and old inventions and identify the correct inventor. I mean, it really, I guess the way to put it is the patent system can't work like a kid's soccer league, right? If everybody gets a participation award, the incentive it creates is to participate. So, if the goal is to have more applications and more patents, then run it like a kid's soccer league. If the goal is to actually drive innovation, then patent quality is absolutely fundamental. The system literally can't work without it.
All right. Thanks, Dave. Dan?
Sure. Thank you so much for having me, and happy Patent Quality Week, everyone. So there are a number of angles to justifying the patent system as a whole, but in the spirit of Patent Quality Week, I want to take the justification for the patent system as a way to signify quality, because that is one of the standalone justifications given for the patent system. That is to say, if all of the arguments for and against were perfectly balanced, then if it were a signal of quality, that would tip the scales in favor of the patent system. Or if nothing, else were on the table, that would justify a patent system. Now, there's the question of how would we design a system that simply functions as a signal of quality rather than getting all the other costs associated with the system. That's a conversation for another day. But I think if we're going to view the patent system as a way to signify the quality of invention, as a seal of approval, as a grant from the government to signify that you satisfy a number of important requirements, I think there are two important caveats that have to come with that if we want to say this is the reason, or at least one of the reasons, we have a patent system. First, we need to make sure we get it right on the front end in terms of the inventions that we are giving. If a patent granted turns out to not be subject matter eligible, or if the patent granted is in fact not novel, or it wasn't non-obvious based on the state of the prior art, well, then that is bad, not just because you've given out a grant of exclusivity that can be enforced against others that should not have been granted, excuse me, but also to a certain degree, it is unfair to the person who got the patent in the first place, because they went forward thinking they had a good idea that it later turned out they did not. So that's bad for the justification for the patent system, because it turns out in this case, it wasn't a signal of quality. And I think the second and more and broader reason we should care about patents as a signal of quality is that depending on how we set the bar for what you need to do in order to get a patent, that indicates our priorities from an industrial policy perspective. That indicates what we want to do. Do we want to make the bar for getting a patent relatively low so that we can have all sorts of software patents or minor incremental, I'm hesitant to even call them improvements, just tweaks to pharmaceuticals? Do we want money going after those changes, improvements, whatever, or do we want to design a system where there's a relatively high bar, so things that are truly new and that truly move the ball forward in terms of invention and progress are able to get those patents? So where we set the bar matters, how high we set it matters, and that's the other important implication for patent quality.
All right, thanks, Dan. Preeti?
Sure, I'll share my perspective from the perspective of a patient advocate. So I've spent many years working with families and patients who can't afford their medication. I've seen firsthand what the impact is on families who can't afford their medication. It prevents people from being able to go to work. It prevents people from providing their families with other basic necessities, whether that's food or paying the rent or sending their kid to school. In many cases, we see people's health deteriorate. People have reported, loss of life in our country, in America, in 2022, because people couldn't afford their medication. And so when I think about the patent system, it is one pillar, in the entire medicine system, from R&D all the way through to healthcare delivery. But it's an important one because it serves as both the entry point for innovation and medical, therapeutic advances. It also serves as a blockage point for families to be able to get the medication that they need. There are drugs even this year that should have come off patent, where people should have then seen a difference. They should have had choice. They should have had lower copays. And we're not going to see that. We're seeing generic and biosimilar entry being delayed time and time again. One doctor I spoke to recently said, the profits are just bloated in this area. Once you start talking about patents being given, particularly to the biggest drug makers in the country at the later stage, well past FDA approval, well past the point where these drugs have been on the market for a long time, that's where we're just seeing friction in the system. We're seeing excessive bloating, and it's patients that are being harmed. I think this is a big moment of reflection for the country. We've seen prescription drug costs, double, I think, or even triple over the last decade, poised to double again. I think there's a lot of pressure on lawmakers to think about what to do. Patent quality is the entry point to thinking about solving this problem, because if we don't, the healthcare system is going to implode on itself at the rate that we're going. And so this is the moment to actually take patent quality seriously as a problem, to start to look at the evidence and understand where are the places, in a principled, evidence-based way, can we start to think about where that excessive bloating is happening? What are the policy solutions that are going to be effective to address it? And how can we give Americans the relief that they so desperately need?
Great, thanks, Preeti. And then hopefully we can get back into that and some of the work IMAC's done on sort of empirically looking at those costs and impacts. But let's jump over to Matt right now and hear your concerns about patent quality.
Yeah, I thought it'd be good to start with sort of a 10,000-foot view of what the patent system is and what it isn't. So, what are patents? Well, patents are a pretty good tool for promoting innovation. And that's fortunate because it's basically the only one we've got. I mean, we've built most of our innovation policy around the patent system. You know, in drugs, especially, there are other tools available. And we've seen that a lot in the sort of COVID vaccine investments. But again, it all kind of defaults to patents. You know, the vaccines are patented products. And so, you know, there are some successes and failures. And so what are patents not? Well, for one, they're not a tool for low prices. You know, there is some arguments that competition occurs amongst patented products. In drugs, we don't really see that, at least not to the degree we want. The savings are exclusively when generic competition comes in. Then you see 80% price cuts on average. Patent system also isn't perfect. We've seen lots of examples of manipulation occur, and there's a lot of incentive to manipulate the patent system. In the drug industry, we call this opportunistic behavior patent thicketing. That's when, you know, you have a product that's about to go generic and you look for ways to build a patent wall around the product that already exists on the market, has already been invented, in which the, you know, innovation has already kind of happened. And finally, patents don't always produce new innovation. Put simply, old innovations need to go off patent for there to be new innovations. There's a forthcoming paper from Brian Lemus and Marshall that examined the COVID crisis and said that, you know, when small tweaks were easy and protectable, and longer run big innovations were harder and more risky, R&D dollars chased the short run innovations, even when, you know, they were imperfect and didn't really produce the value that we wanted. So how does this relate to patent quality? Well, there's a huge incentive to seek patents divorced from whether they actually represent progress and innovation. And so, you know, that's a big failure point, it's a big problem. And that's largely what we're talking about when we're talking about patent quality. The public interest is in receiving a valuable innovation exchange for this grant of a monopoly. So when we talk about quality, you know, what we're essentially asking is, what's the innovation? What are we getting as the public in exchange for each issued patent? And, you know, in terms of the actual patent system, the more we go towards a system that says, if we can check all these boxes on a list of formalities, then the patent should issue, then it's easier to manipulate. And, you know, we already know that there's incentive to manipulate, and that's going to drive low quality patents. The more we ground the system in sort of this examination of what the innovation gains are, the more we have high quality patents, and the more, you know, we have newer innovative drugs that go on the market, and these older drugs that are affordable to patients.
Great, thanks. I think you all brought up a lot of good points, and now I just want to dive into some of the issues that you raised and sort of explore them a little bit more. And it seems to me like, well, if we are talking about patent quality, there's sort of two components. First is, how do we ensure that only valid patents are granted? And the second piece is, if an invalid patent or a poor quality patent gets into the system, how do you get that out of the system? So I don't know, maybe Dave, start with you. Is, you know, how do we make sure that we're only getting the valid patents that provide innovation into the system?
So I think ensuring that we're absolutely perfect in only granting valid patents is impossible, or at least impossible in any practical price, right? So it's really a question of balance. I mean, currently the U.S. spends substantially less on examination per patent application than most of our, or I think all of our, except maybe for China, foreign competitors, right? So I think that step one is just provide adequate resources. I don't think throwing money at the problem will necessarily solve it, but I think that giving examiners more time, better kind of IT resources in terms of prior art databases, and just better support generally would improve things quite a bit. There's also a number of things that can be done in terms of the internal processes at PTO that are not very exciting, but that would probably increase patent quality. And then kind of one thought in terms of a major change that would likely be very controversial and would never make it through Congress. You know, right now, the office bears the burden of showing that something is unpatentable instead of the applicant showing that it is patentable, right? So right now, if an examiner is overburdened or not very motivated, the default is that the patent will issue, instead of the default being that the work doesn't get done, so the patent doesn't issue. I tend to think that's a real problem. I'm not sure how it gets solved. I see some concerns also with putting the entire burden on the applicant, but I feel like applicants should bear more burden in terms of justifying the patent than just filing the application, and then if the examiner doesn't do anything, the patent issues. That seems like a system that is destined to generate low quality patents.
Okay, great, thanks. So it does seem that there are things that can be done with just administrative within the patent office to actually improve the quality of these patents. And Matt, I just wanted to follow up with something that you said. You were talking about the role of patents in terms of boosting innovation. And it seems that patents walk this fine line between sort of getting inventions onto the market versus protecting monopoly profits of those who have a patent. And I'm wondering, do you think the current system does that effectively?
I don't think the current system does it effectively. And I think the evidence of that is definitely found in the drug industry. And I'm sure David will have some examples in the tech industry as well. But just the fact that a product that exists that's on the market, these patents are supposed to be rewards. They're supposed to be, in exchange for innovation value. And so being able to build these patent walls around a drug that exists just doesn't seem like it should be possible. And yet we see lots of examples of it. I mean, if you're a Humira patient today that's struggling to afford your medication, it's 100% solely due to the patent system. In other countries, the drug has gone off patent, and a lot of them, the prices have dropped by the 80% that we typically enjoy here when a drug goes generic. And so I think that, the onus should be on one invention, one patent. And if, I know that follow-on innovation exists and happens, but we're just not seeing a lot of actual improvements. It's more of just legal gamesmanship.
Great, thanks. And Preeti, I was wondering if you could follow up on that, because I know IMAC and some of your research has really looked into what the impacts of patents and patent tickets and these product copying, those kind of practices on the important drugs from Humira, some of the other ones that you've gone over. Could you just give us an example of how these maybe overly broad patents or lower quality patents are used to impede competition?
Yeah, so when we've looked into this problem, what we found is that in our country, companies are filing for more patents, they're getting more patents, and then they're asserting more patents in litigation, right? So across the system, we're seeing just higher volume per product in terms of how the patent system is being used. The research that we put out a few years ago, which is probably out of date by now, but we were showing that there were a very high number, over 100, I think it was 131 applications on average were being filed per drug product. Over half were being granted. And if I recall correctly, it was nearly 2 out of 3 patents, patent applications were being filed after the drug was already being approved by the FDA. So what that means, in plain and simple terms, is exactly what Matt is saying. In other countries, we're not seeing this. Humira is a great example because it went biosimilar. There was competition in the market in Europe by 2018, I believe. So when you look at the difference, then what is America spending in the years that we don't have that competition? We're spending $70 billion. Now, another good example I really look at is Revlimid, the drug for myeloma. It's a drug product that came onto the market a long time ago, in the early 2000s, I believe. It should have come off patent, but the company who owns the patents on these drugs, they started to file for more, right? And this is a common practice. The Congressional House Oversight Committee put out an investigation, a report in December, really just showing in drug makers' own words that this is the practice. When you see that your patents are about to expire, there's about to be competition on the market, you start to think about, well, what can I do with this product? Can I stick a new device on it? Can I make it look different? Can I dress it up? And how can I hold on to the market for longer? So in the case of Revlimid, we started to see polymorph patents. Those are crystalline forms. You know, crystalline refers to crystals. It's like ice and water. It's two different versions of the same product. And so they were able to extend that period of exclusivity. Now we're not going to get the kind of competition we should be getting until 2026. So what that means in terms of the math is that on Revlimid, because it's a high spend drug for public programs, we're going to be spending about $45 billion more than we should be on this one drug. And so I think if you look across all of the top grossing drugs or the highest cost drugs in America, we're seeing that we're just spending tens or even hundreds of billions of dollars across these products. And is this really what we want when these aren't new drug products at all?
Great, thanks. And Dan, I'd be curious on your thoughts on how do we maybe right the balance between innovation and protecting monopoly rents? I know you've done a lot of work on that.
Yeah. So I think as far as if we're seeking the correct balance for something when we're talking about the patent system, we need to consider we need to do sort of a but-for analysis, where but for the grant of a patent, would this new product have come onto the market? And I think, and then we look at sort of what do we want to come into existence? What do we need to come into existence? And what could we live without? And we figure out, based on that analysis of what do we need, what would we like, and what can we live without, where we're going to draw the line on novelty, on obviousness, on subject matter eligibility. And for those who are able to really reap the benefits of commercializing and bringing their products to market and making it available, it's not necessarily problematic that they would be making above market returns. What does get into, where we do get into murky territory, is when we see significant cost to above market returns, particularly if we're talking about access to essential medicines, if we're talking about access to essential technologies, if there are barriers to competition that prevent entry, so that way those rates, those economic rents can eventually be self-liquidating. So I think the important way we balance, and there's no one-size-fits-all solution for the patent system at large, or even for a particular technology sector, is to sit back and consider not just, is this new? Would this thing not exist without the patent system? But also considering all of the costs, the ability to block competition, the ability to charge what are often simply monopoly prices. What can we, where are we going to draw the line on what should be brought into production, and how important is exclusivity to that?
Great, thanks. Yeah, and now I want to turn now to the second question, and this is maybe has generated a little bit more controversy, and that is the idea. Okay, we know not all patents are perfect, and we have invalid or overly broad patents in the system. How do we address those, and how do we are there processes in place to get rid of those and make the patent system work better? And Dave, how about starting with you on this?
So I guess in my view, the best system, and I think you just sort of implied this, is to not grant the bad patent in the first place, right? That's the ideal world that everybody should want to live in. The second best world is to have some sort of relatively efficient, relatively accurate, again, a second best system of administrative challenges that allows you to invalidate the patent. And the third best option, or maybe the worst option, is to allow people to go to court and enforce those patents, sometimes at the cost of billions of dollars to corporations that actually make products that benefit consumers. So there is right now a fairly effective administrative system for challenging patent validity. It consists currently of two processes, one called PGR, referred to as PGR, which stands for post-grant review, and one that is referred to as IPR, which stands for inter partes review. Inter partes review is the one that is much more frequently used. And it's been, I would say, over time, a pretty significant success, although less so in recent years due to some kind of not very well thought out reforms. I mean, if you look at the results of IPRs, they're an order of magnitude cheaper than district court litigation. And an IPR costs somewhere in the neighborhood of $350,000, which is a lot, but not compared to district court litigation for a small to medium sized case, which is $3 to $5 million, right? So order of magnitude cheaper in terms of cost. It is almost invariably faster, right? It'll reach a result faster, which is important both for the alleged infringer and for the patent owner, right? Both parties need certainty so they can get on with whatever their business is. And then third, it's proven to be accurate, right? So the fewer of the IPR decisions are overturned by the Federal Circuit than district court decisions on validity are overturned by the Federal Circuit, suggesting that they're reaching the right result. So yes, we do have a system right now that works relatively well in terms of allowing administrative challengers that is actually faster, cheaper, and more accurate than taking these cases to court.
Great, thanks. And Matt, maybe I can follow up with you because I know you're a lawyer, and so you can address. It seems to be that over time, I think there's been swings in the patent system where sometimes it's gone too far, and then we've pulled back, and I think we did see that in maybe the last decade or so, where there's been some serious concerns raised by the Supreme Court on some of the patents that were being issued. Can you talk about sort of what flashed the interest of the courts, and are they actually making a difference in making the system more efficient?
So, this is kind of an interesting area. I think that the Supreme Court kind of shows the benefits of having generalist judges look at patent issues, because when Supreme Court takes up a patent case, they're usually looking at it through the lens of the public interest. And so the mechanics of, how the patent issue, what's going on, what that says, is only one factor. And so I think that largely when Supreme Court takes up a patent case, their decisions are heralded by public interest folks like myself, and disparaged by people who are heavily invested in a maximalist patent system. And so on the other side, there is the Federal Circuit, which is very much revolves around and has a lot of advisors in the patent bar, and it's again sort of that formalistic type of thinking, which I don't want to disparage. I think that there's a big place for that, especially amongst lawyers, but they're not really thinking of the public interest as much. And so sometimes you get cases out of there that that we look at and we say, how could this happen? There was a TIVA case around skinny labels that happened recently that kind of woke a lot of us up, saying, how could this issue? It's pretty bad for the public interest. But that's typically been the balance. And my professor was Paul Gugliuzza, and he has written pretty extensively about sort of that kind of dynamic. And so that seems to be the tension that has historically existed and continues to exist. It's just the Supreme Court has, there was a flurry of cases that they took up, and now I guess now they're about to take one up again, but they haven't been taking up as many lately. And so that seems to kind of be in the legal system where the pendulum swings, where every once in a while the Supreme Court will say, hey, we need to jump into this, and then they take up a flurry of cases, and then they kind of ignore the topic for a little while.
Yeah, great, thanks. And Preeti, and I had a question for you, just in terms of, I know you advocate for reforms here, and how easy is it for you to sort of engage in the patent system and get your voice heard, or are there things that could be done to the patent system that would make it more responsive to concerns from the public and others?
Yeah, this is something we've spoken a lot about, that for the public to engage in the patent system in a meaningful way is extremely difficult. It's very hard to go to court. You know, we've seen cases over the last 2 decades where groups have tried to go all the way up to the Supreme Court, often told that they don't have standing, legal standing, because you have to have a commercial interest in the outcome. It's not enough to be an affected member of the public. We've seen cases brought on these patent thickets where in antitrust cases, where judges have thrown their hands up and said, look, it's clear that there's too many patents on these drugs, but antitrust law doesn't allow us to deal with this. We have tried to file patent challenges at the patent office, tried to be heard. Now, it's very expensive for a patient group or for civil society, for us to go and challenge legal cases. You're talking about nearly $40,000 per patient. So when you, per patent. So when you talk about the total number of patents on a drug, let's say you even want to challenge 10 of those patents, you're talking about hundreds of thousands of dollars just in filing fees alone. And then when you do file, you know, your cases are not heard. And I think this goes to, I appreciate what Dave said earlier, you know, when you're talking about examining patents up front, right? Maybe if we gave the patent office more resources, maybe if we gave our examiners more time, maybe we would get better quality of patents. I want to go one step farther. Whether you're talking about examining patents or you're talking about legal challenges that are heard afterwards, I think we need cultural mindset change. I think that in the community, particularly at the patent office, there is an entrenched over time belief that the public, if we choose to try to participate in the system, we must be mischief makers or rabble rousers, and therefore we need to shut the door on public interest actors immediately. We've seen this time and time again. We saw HIV prevention groups last year try to bring a very technical and very legitimate issue around patent term extensions to the patent office to try to be heard. And not only were they not heard, the legal advisor in question took to Twitter to denounce the group for saying anything negative about the pharmaceutical industry, because the industry can only do good things and they spend so much money on R&D. So how dare this group bring an issue like this to the patent office? This is a cultural problem. It is a structural, architectural problem of how agencies are run. You know, first of all, we need more oversight in our country of the patent office. Issues like this, there is no place for us to come and approach members of Congress about this. And slowly that is starting to change. Over the last year, more members are asking many of us in the public interest community, okay, then what needs to change? We hear you, there needs to be more oversight. We hear you, there needs to be more spaces where you can bring these pieces of evidence, your stories, how your lives are affected. We've had wonderful conversations with the PTO about what would it look like to put more people onto the PPAC, the Public Advisory Committee that advises the director of the PTO. That's slowly starting to change. What would it look like for the US Patent Office to have an Office of the Public Advocate? You know, these are all incremental steps that we talked about in our, we put out a policy blueprint that's on our website called the Public Participation Blueprint that offers a roadmap, you know, culling the opinions of many stakeholders of where these barriers are and what can change. But it's a serious problem. I have worked all over the world. I have worked with patient groups in all kinds of emerging markets and low-income countries to help them go and just engage with patent offices and be heard. I haven't seen anything like this, where everyday Americans can't have their voices heard and their input meaningfully integrated into the system. So for me, even before we start to address the quality of patents, this is a cultural mindset problem that we have to start fixing. Oh, you're on mute, Wayne.
Yeah, a fire truck went by, sorry. Dan, I wanted to sort of take a step back with you, and I know you've done a lot of thinking on what is a patent, and you know, there is one view that it's tangible and it's like real property. And if you take that view, it seems it's very difficult to suggest changes because they say this is property like anything else. Alternatively it could be considered a grant of exclusivity from a federal agency, and that gives you more flexibility in terms of that this is something that is a public policy to begin with, and it's fair game to talk about changes to public policy that would make the patent system better. Can you sort of talk about that a little bit?
Yeah, I think there are, I guess, conceptual, or there are roadblocks to improving the patent system that deal with how we interpret patents, or what is this thing that we are looking at. On the one hand, if we view it as property in the same, not just in the technical sense or the way you can treat as property employment or contracts or something like that in a very technical legal context, just because there are features of property that it makes sense to apply to in this institution. But property as in, if you take this away from someone, then you've done real harm, and that it is a right that ought to be respected for its own sake, then yeah, you're going to run into a lot of problems for patent reform, because if you're going to violate a right that someone has, then you need a really good reason in order to do that, where simply this is, world A is better than world B won't cut it. Fortunately, that's an incorrect interpretation of the patent system. It's a grant of regulatory exclusivity. If you're feeling particularly spicy one day, you could call it a monopoly. I call it a regulatory subsidy, because it says we're going to, create a certain period of exclusivity for you to recoup costs, to create incentives to commercialize, and do all of these important things. And I think, so when you think of it purely as a policy, there's no need to get misty-eyed or romantic about it. We have a policy designed to achieve a certain goal. If it does, that's great. If it does, or either if it doesn't, or if it does with significant costs that call into question the overall value of the system, then you just need to take a more dry, clinical look with no passion. And I think that is an excellent opportunity to build on the point that Preeti addressed. And when you have one of the reasons that I think the view of it as property, again, not just in the technical legal sense, but in the something that ought to be respected for its own sake sense, when it becomes too dominant, when it becomes the general way we conceptualize it, then it becomes harder for the public to enter the conversation and really and really influence the conversation in the way they deserve, just because the public does not necessarily get veto rights on something that you yourself have a right to. But when we make it abundantly clear that this is a policy tool, that in a democracy we ought to have government expenditures, government grants of exclusivity, things like that, really evaluated by the public at large. Once you move more towards this view of it as a subsidy, then you're able to see a lot of progress. And that includes making it clear that the public deserves a seat at the table, and a prominent one at that.
I just want to add one thing to what Dan said, that even if you're a subscriber to the view that intellectual property is the same as real property, when you have real estate, you have zoning restrictions, you have easements, you have eminent domain. I mean, these things kind of have similar facets in 1498 Marchand, but when you try to do that with patents, people riot. And so it's like, it's not even just like we wanted you to treat this like real property. It's like we want you to treat it like super property rights.
Great. And Dave, I want to sort of follow up a little bit on that, because I know in the tech world, we saw this whole phenomenon of the sort of the business method patents, which were basically just as you found a digital way to do something that was a standard business practice, it was suddenly patentable, and the courts got cluttered with these cases. And this is, I think it's an area where you do see this flood of patents that maybe should not have been granted in the first place that are in the system, and how do you get rid of them, and maybe go into a little discussion of why they can be particularly harmful, because you have groups that tend to just collect these patents and use them as a way to thwart other innovators rather than promote real innovation.
Thanks, Wayne. I'm happy to talk about business methods. And this goes to a certain extent, I think, to something Dan mentioned about is patentable subject matter. Like what types of inventions are actually useful if you provide patents? Will you get more inventions? And the answer with business methods is you don't get more innovation by granting patents, right? There have been actual studies that looked at companies who actively applied for business method patents. And then there was a Supreme Court case that, intervening Supreme Court case that basically said you can't get business method patents, or only in very kind of narrow areas, or, it's very unlikely you're going to get a business method patent. And so these companies stopped applying for business methods. And what this study found was they then started increasing the amount that they spent in R&D, technological R&D. So at least for that class of companies and that class of patents, granting patent protection actually reduced their R&D expenditures. It actually actively hurt innovation rather than helping it, which is something that obviously the patent system shouldn't be doing. I'm sorry, Wayne, I've gotten the first part of your question, but I've forgotten the rest. Was it, why can they be particularly harmful? Business methods actually turned out to be pretty harmful for two reasons, right? And both were technological. One was the adoption of the PC and kind of computerization of everything. And the second was the, putting everything on a network, right? The advent of the internet and the advent of networks. Both of those result in a situation where if you grant, imagine you have an old way of selling dog food over the, selling dog food in a brick and mortar store, and then you give people a patent for the same method or a, substantially similar method, doing it over the internet, right? There's no innovation there. It's obvious to say, oh, well, we've always sold dog food this way, and now there's the internet. We're going to sell it this way on the internet. So you get zero in terms of innovation, but everyone trying to sell dog food over the internet, which is perhaps the one of the main ways people now sell dog food, is going to be subject to an infringement suit. And arguably, people who have third parties beyond just the person selling could also be liable. That creates huge problems. That lets unlike the drug world, where a patent perhaps could be asserted against one or two or three kind of competing generic drug makers, that creates a situation in the tech world where a patent could theoretically be asserted against thousands, maybe even hundreds of thousands or millions. In some cases, the theory would extend all the way to consumers themselves. So you're looking at a system where a patent could be asserted against 300, 400 million people in the United States. And that's one of the things we started to see happening, right? You'd get people who accumulated these patents, not the inventor, but people who bought them secondhand on the secondary market, going after companies like mom and pop kind of coffee shops, right, for providing Wi-Fi. And that turns out to be, I think, a real problem ultimately. It's obviously a problem for my members, which are big tech companies, but the real problem is for the small entities and the individuals who get a letter in the mail saying, pay me $10,000 or I'm going to take you to court. And so they call up a lawyer and the lawyer says it's going to cost you $100,000 to defend the case. And so you go back and you pay the $10,000 holdup fee, and that is just terrible. It's terrible for commerce. It's terrible for innovation. So that's at least my perspective on why they're so bad.
Great, thanks. And Matt, I wanted to follow up with you on that. It seems like once that was sort of identified as a problem, Congress did step in and pass the American Invents Act. And I know David mentioned the IPR process. Can you talk a little bit more detail about what the importance of the American Invents Act was and why the IPR process was a step forward?
Yeah, the AIA was a true piece of compromise legislation that kind of gave everyone a little bit of something that they wanted. The main thing the public got was the streamlining and improving of the ability to challenge issued patents, which is, of course, a big patent quality tool. And so the IPR process basically put, on an 18-month calendar and reduced the cost of sort of asking the patent office itself to take a second look at patents rather than go through a court challenge, which, I think averages around 4 years and several $1 million, the same thing. And IPRs, like Prithi said, was you know, 40 grand in filing fees plus attorney's fees, I think brings it to around 100 to $200,000 if you have to hire an attorney to do that. And so, you know, it's a huge improvement for the public. The other important thing is the public gets to be a participant. I mean, most participants of the IPR, vast majority are businesses that are impacted by patents, you know, and drug space generic companies bringing them so they can bring new products. And, you know, companies have been sued, but there's been at least one instance of a public interest group, the Electronic Frontier Foundation, canceling a podcasting patent that was used against a lot of, you know, what are now people's favorite podcasters, but back then was just this kind of fledgling industry that was, you know, people's hobby. And now, you know, you've got WTF with Mark Maron's top podcast. He was one of the people that was threatened with this patent by a patent troll. So I think that the public participation aspect is actually pretty important, at least as an available avenue. And again, it has huge advantages in both time savings and money savings.
Mind if I could just weigh in on that a little bit on top of Matt. I think Matt's exactly right. But in my view, that's a kind of incomplete picture of the benefits. I mean, just having the system in place deters people who own invalid patents from asserting them, right? So in many cases, a challenge isn't even necessary, right? So you've got a few situations. One, you have a challenge, the patent's invalidated, and the person who invalidated it is not the only one who benefits. Everyone else against whom the patent might have been asserted is also benefited. It also basically puts a cap on these hold-up suits or hold-up kind of assertions where, you know, the owner of an invalid patent knows that if they ask for too much or ask too many people for a hold-up settlement, then there will be a challenge. And they will then moderate kind of the amount that they're asking for, the number of people they're trying to hit up for money, which, you know, is not fantastic. I mean, it's not a complete solution, but it actually, in my view, it was kind of a sea change in the world back at the time of the AIA, because suddenly a lot of these assertions, which have been very common, with some people asserting against tens or hundreds of thousands of entities, just went away because they knew that their patent was invalid and they knew that it would be invalidated if they created the set incentive to invalidate it through assertion.
Dave, could I just follow real quickly on that with you? I mean, there's been a lot of people who point to the IPR as sort of a death squad for patents. Can you sort of address that situation and talk about how the IPR actually works?
Well, I guess I mirror what the former chief judge of the PTAB got in trouble for saying, and I'll probably get in trouble too, saying it's supposed to be a death squad for patents, right? It's supposed to be a death squad for invalid patents. Right. So, you know, it is a problem if you're canceling valid patents that represent true innovation. There's no indication that that's what the IPRs do. Like, as I mentioned before, the results in IPR are as or more accurate than the validity determinations by courts. Right. So there's no reason to think that somehow, you know, it's a death squad in the bad reason, like, you know, that it's actually canceling invalid patents, you know, but it wouldn't be doing its job. This entity exists only to hear patent challenges. That's not technically true because they have a second mission as well. But, you know, IPR, I guess, is more accurate to say that IPR exists only to challenge patents. If no patents are being canceled from that process, then the process is pointless and it's not meeting its objectives. I guess the last thing that I would say is that if you look at the kind of cancellation rate in IPR, it actually over the past few years has dipped to be lower than the rate of invalidation in litigation, right? So the chances of your patents being, you know, all other things being equal, your chances of the patent being invalidated in IPR are lower than if you go to court, right? Which to me just destroys the entire argument that somehow the PTAB is anti-patent or, you know, is killing good patents or destroying innovation. It just isn't. I mean, the other indicator you can look at is that the PTAB's invalidation rate is substantially lower than that of similar administrative processes in other countries, right? So in Europe, you're much more likely to use your patent in administrative challenge than you are in the United States, right? So, you know, any way you look at IPR, I think it's really, really hard to support the argument that somehow something evil or malign is going on that inappropriately or improperly deprives people of rights.
Yeah, just to follow up real quick on Dave's point. I mean, we looked at this a few years ago as far as what is the IPR actually doing. And I think that calling a death squad like vastly overstates the actual impact. I mean, what we found was if you look at the patents issued annually and then the patents were canceled annually by IPR, it was less than 1%. It was 0.12% of total patents and 0.3% of drug patents. And if you compare that to sort of my go-to study, which I forget the author, but he was correcting for selection bias, so it's probably trust a little bit more, but he estimated about 27% of all issued patents are at least partially invalid. So the IPR is not like, you know, having this huge culling effect on patents by any means.
I think Matt's probably referring to the Sean Miller paper. Is that right?
Yes, Sean Miller. Yeah.
Great, thanks. And Preeti, I mean, just in your perspective and from your looking at the patent system, does the IPR system help in terms of what you're trying to accomplish?
Definitely. I think, you know, somebody mentioned this earlier. We always want to see poor quality patents not get granted in the first place to maintain the integrity of the system. But after they are granted, in the current system as it exists, after they are granted, you have to have mechanisms to be able to do that second review, to be able to say, okay, if we made a mistake, let's correct for it. And this matters for healthcare costs, because if you don't have that, right, then there's no ability to correct for mistakes and to get drugs to market sooner. Of course, that's why we always say improving how patents are reviewed in the first place is the most important thing to curb those costs before they even occur.
Great, thanks. And Dan, I don't know if you want to touch on, I mean, in the previous administration, the USPTO director took some administrative changes into the IPR system, and it seemed to sort of narrow the scope of what IPR could apply to and how people could use it. Can you talk about that a little bit and what that did to the process overall?
Sure. So briefly, in the previous administration, what you saw was a general narrowing of the circumstances under which you could institute an IPR. So the decision to institute an IPR, it's not automatic. Unlike you know, to actually hear it, and there were a number of decisions that were designated as precedential that determined, okay, this is what we're going to do when we want to determine whether or not to have a petition. And one of the more troubling ones excuse me, dealt with whether or not there is parallel district court litigation. So oftentimes what you will see in the context of an IPR is, you know, Wayne, you sue me for patent infringement in district court, chances are in Texas, and then I go to the PTAB and I say, you know what, you could sue me for infringement all you want, but let's go to this cheaper venue and determine whether or not you actually have a patent in the first place. And what you see are previous administrative decisions that questionably or that potentially exceeded the statutory authority to deny the institution of IPR because there was litigation going on in the district court, which, leaving aside whether or not it exceeded the statutory authority, is exactly backwards. Anytime lawyers get involved, it's not going to be cheap. But when you're talking about hundreds of thousands of dollars to figure out whether or not the patent exists versus millions of dollars to figure out A, whether or not the patent is valid, and B, whether or not it was infringed, it's not even close which one would be the preferable option. And that, of course, would be the IPR process.
And Wayne, if I could I just jump in and comment? I mean, so I think Dan did a good job of outlining the reasons that the changes were bad in principle. I just wanted to note that they're also horrible in practice, right? So the one that he mentioned about parallel proceedings relies on the scheduled trial date in a district, parallel district court proceeding to deny an institution of a challenge to a patent. Right, and in the very case that resulted in the main precedent in this area at the PTAB called FinTIV, they relied on a district court trial date that has been changed multiple times after the denial. Right? I think in FinTIV they've had, if I'm not mistaken, 6 different trial dates. Right, and now and the case has never gone to trial. I think it's currently scheduled for later this month, but there's no guarantee it'll go to trial there. And that's after, I don't know, 2.5, 3 years, right? So beyond just the kind of, principled problems that Dan pointed out, the way that this was implemented is just absolutely wrong. And people have looked at these trial dates that are relied on by the PTAB, and a group, including the former solicitor of the PTO, found that 94% of the trial dates are wrong. 94%. So the idea that a U.S. agency would be relying for this on a class of data or a class of evidence that they know is only going to be right about 6% of the time, to me is just astounding from a just a common sense perspective beyond the principled objections.
Great, thanks. Well, we're sort of running out of time, so if anybody has questions, feel free to put them in the Q&A box. But I did have one question we can sort of kick off, and that is, I know we have a new director of the USPTO, and there may be new directions that she's interested in moving. But I wanted to know whether you think the USPTO can reform itself, or does Congress need to step in again and sort of lay down some new guidelines? And I'll just go around on that one.
So if you want me to go first, I'm happy to do it. I think the answer is both, right? I think that the PTO is very much capable of reforming itself within kind of fairly narrow band of changes. The problems are twofold. One is that they are banned by statute, right? So they only have limited ability to change. And the second problem is those changes are unlikely to be permanent. Right? Not unlikely, it's almost impossible to make it permanent, right? The next director can choose a completely different policy, which is not fantastic for US business, right? If things are kind of, swinging back and forth and ping-ponging every 2 to 4 years with the new director, that's a problem. So there's definitely a role for the new kind of director of the office, who I have a lot of confidence in. I've known for a number of years. Although not super well, there's a role for reforms that are driven just by the Patent Office. But if you want those reforms to be A, meaningful, and B, permanent, then you have to go to Congress.
Great, thanks. Dan, any thoughts?
Yeah, I mean, the short answer is both. The long answer is there is simply no substitute for a statutory fix, especially because, there's, it would be a cruel irony if here I was just a moment ago complaining about exceeding statutory authority, and then I advocated the USPTO to exceed statutory authority, but in a direction that I liked. I think one of the issues that reason why I think Congress really needs to get in the driver's seat, not just on the way we grant patents and the organization and capacity of the USPTO, but it also really needs to take a long, hard look at what the bar is for actually granting a patent. And I think if, as long as we have laws that, at least on paper, at least in theory, allow the granting of modest, again, I'm hesitant to use the term improvements, but just modest tweaks to products from semiconductor chips to drugs, that ultimately requires a statutory fix. But again, it's both.
Okay, great. Matt?
I think that Dave kind of hit the nail on the head. Patents are 20 years and administration is 4. And so, it's great if Kathy Vidal really digs in and tries to take a look at this and proposes some solutions to patent quality. I think that the question is whether or not that lasts to the next administration, or, if Biden gets elected, another 4 years after that. And it's not great to be ping-ponging too much on this stuff. I think that the better thing is to have longer-term conversations and steering that comes from Congress rather than from the USPTO. I think the best role for a USPTO director is to help provide the information that Congress needs in order to make good decisions.
Great, thanks. And Preeti, I guess you get the last word, because we're coming up on the hour here, so.
Well, I think they've said it all. The one thing I'll add, I'm not from Washington. This is probably one of my first times being, virtually on the Hill to have this sort of a conversation. I'll say that in terms of what needs to change for Congress and Kathy Vidal to be able to do something is a complete rejection of this frame that I'm only now really coming to understand about being pro-patent or anti-patent. I think it is a false frame. I think it is an industry advanced frame that you're either for us or against us. And I think it is simply not true. There are so many of us who care deeply about our country's patent system, who care deeply about the advancement of science and medicine and making sure that people can get the benefit of those fruits. So when we talk about patent quality, we are talking about imagining the patent system to move forward into the 21st century. When people say that they are pro-patent, what they are actually saying is that they are pro-status quo, and they do not want anything to change. So I just want to underscore that this whole conversation is about evolution, it is about forward movement, and it is about progress. And I think for lawmakers and PTO officials, including Kathy Vidal, to really sit with that and think about, well, how do we integrate that into advancement and policy is going to be an important first step.
Great. Well, thank you. And thank all the panelists. I think we are at the end of our time. Unfortunate, because I have a lot more questions and we could go on forever, but I want to give everybody their day back and thank the panel.
Thanks, Wayne. Thanks all.
All right, appreciate it.
Thank you.
Thank you all.